Enterprise TV, a tradition of truth.
Well, the case under reference, before we come to whether the court is right or wrong, the case that was brought before the court was that of fundamental right enforcement of Nnamdi Kanu's right as a citizen of Nigeria, as regards the way he was being treated by the DSS in their facility. Okay, so he brought this fundamental right enforcement proceedings before the court, asking the court to restrain the DSS from maltreating him. That first, they don't allow his lawyers to see him, even during visiting hours and visiting days. And even when the lawyers eventually are allowed to see him, they restrain the lawyers from going in with notepads to make jottings. And in one situation, they took documents which the lawyer brought in to show Nnamdi Kanu, took those documents forcefully from the lawyers, intimidated them, and made photocopies of all those documents. So those maltreatments cumulatively were what he brought under that suit and asked for damages for the injuries so committed by the DSS. Now, Justice James Omotosho of the Federal High Court in Abuja delivered a judgment to the effect that Nnamdi Kanu could not prove those allegations, could not prove them for the court. And you see the limitations of our courts and the limitations of the judicial system the world over is that the court will be asking you to bring material evidence to prove you were maltreated. How would Nnamdi Kanu, how would he have gotten material evidence inside DSS facility? How would he have gotten that? Okay, could he have recorded the DSS officials under that condition? Could the lawyers have taken materials in to record the way the DSS treats Nnamdi Kanu? Do you understand? I was not in the case. I was not a counsel in the case. But if I were to be a counsel in the case, I know how our security agencies treat Nigerians. Many of them are unteachable and untrainable. They didn't get those jobs on merit. And that is the danger of getting jobs with man, no man, and money. Most of these officials, some of them can be professional, including the EFCC and all that. For some of us who have been in detention before, I know what I went through, even as a lawyer. And I know what other inmates who were not lawyers went through, who were more degrading than the treatment they merited at me. So, I don't know how far the lawyers went, but the Evidence Act, okay, gives you an opportunity, okay, to ask that if there is an inculpating evidence in the hands of the adverse party, you can make an application before the court that the evidence that could have brokered this case, unfortunately, my lord, is in the hands of the adverse party. And you are making an application to ask that they produce such evidence. I would have made an application for them to produce the CCTV footage of the allegations that I'm putting forth in these proceedings. Because the court said, there are no evidence. You didn't prove it. The court is not saying, I don't believe you, or I don't think this could have happened. But the court is saying, you didn't prove it. You couldn't prove it. And I'm saying the court should look beyond. You see, we have gotten to a situation in this country where, like, the judiciary is in peril, okay, to suo motu, not to descend into the arena of conflict. That's forbidden in law. But to look at the circumstantial evidence and to look beyond what is materially possible. That is why in law, I think in section 141 of the Evidence Act, it talks about the court taking judicial notice of certain practices in society, that one of which is that Generally speaking, from the police to the DSS to the EFCC to the ICPC, it is a thing of behavior and conduct of the general Nigerian with an authority. He abuses his authority at all times. The court should urge itself at the threshold of that understanding at every point in time when it deals with cases like this, so that a defendant who has been so maltreated, when he cries to the court and says, this is what is happening to me. Section 35 of the 1999 Constitution says that the defendant shall be given adequate time and facility to prepare for his case. It's a constitutional matter. When a lawyer goes into the DSS facility, he should be allowed to see his client. He should be allowed. There's no law that says you cannot go in writing materials to take information from your client. And when you have documents you want him to verify, that's adequate time and facility you are giving the defendant to prepare for his defense. It is not for DSS to seize it and photocopy it. What are they doing with it? Is it voodoo? Is he going to use it to disappear from the cell? Is it going to, so those allegations are found. But again, this is one of those cases where Justice Kayode said, that this case looks up to the high heavens for want of evidence. The court is not going to go outside what is before it. It can be unfortunate, and we can all sympathize with his condition, that of his lawyers. They couldn't have been lying. They couldn't have just gone to court for court's sake. Okay, they may have witnessed certain level of maltreatment, which instigated that, and which the DSS completely denied, knowing that they cannot prove it. But the evidence is actually with the defendant. The evidence is with the adverse party. I don't know whether they made that application for it. And if such application is even made, assuming but not considering that the applications were made, the DSS can say they don't have the footage. What will the court do? So the court is not going to, and once the statement is made, they don't have it. The court is not going to bamboozle them, especially when there is no law that says there must be CCTV installations in our prisons or custodies. So we come to that junction where the person who is maltreated in this country, sometimes, even with glaring possibilities, in the absence of material evidence, cannot sustain an argument. So generally, we cannot, by this same token, say the court was wrong or right. But in the eyes of the law, the court did not err by saying there are no material evidence. But the court also couldn't have overstepped evidence to take a decision because of appeal. The DSS will go on appeal and say the court had no evidence and took a decision. The public will say the courts are incompetent. If the court now fails to take that decision because there's no evidence, some other person will say the court is witch hunting the party in detention. So you see that the judiciary, the court, it's like Mother Earth. It bears a lot of brunt and burden, especially in a society where you have 54, 56% illiterate level, but that's a deficit in knowledge-based society. You're going to have things like this. So from all stretch of your imagination, I think it is better to say that a court is stuck with its own laws or the laws of the land. But what the court has also done, or what the DSS did, has also put society on trial. Just like one of the judges said in the case of the Spellucian explorers in jurisprudence, when he looked at the case or what has happened, miners had gone to mine and the earth caved into them. And when the earth caved into them, they were there for days and could not eat. One of them suggested that we're going to cast a lot. If we cast a lot, if it falls on anyone, we will all kill that person and eat. The person who made the suggestion, the lot fell on him, and they killed him and ate him by their own agreement. When they were finally rescued, they charged them for murder. And the first judge said that murder is murder anywhere in the world, under any circumstance. The second one said, wait a minute, why should you subject them to the laws of the earth when they were caved in under the ground? That underneath the ground, there are laws that exist there. And I'm not sure one of them is that if people have an agreement, they should be charged for murder thereafter. So they kept arguing. One very intelligent judge, the fourth one, says that if we convict these people, it will appear that there's something much more on trial than the act committed. And that is what I see in this case. Okay? Apart from the fact that Nnamdi Kanu is agitating for secession, which the Nigerian state find very offensive, that has also rubbed off on the institutions of government to treat him in the way they do. So his situation is pathetic because it appears that much more than him, there's something much more that is on trial, and that is his ambition. So they are doing all that to ensure that he does not get justice. He's put under stringent condition. Even the federal government itself have said his extraordinary rendition was irresponsible, that was unlawful, that it did not conform to international law and policy on treaty on extradition. And that when the soldiers invaded his house, what they did there can best be classified as an act of irresponsibility. The federal government itself admitted all that and still did not release him. It tells you that what is on trial is much more than Nnamdi Kanu. His ambition is on trial. The fate of the collective of the Southeastern is on trial. Much more than any other thing you can think of. So in the days to come, you will see DSS will get away with more of these shenanigans. Okay. And we were taught in the law school that when a suspect or a defendant is on trial, he should be prosecuted. He should not be persecuted. That is why some prosecution counsel in court, when the court want to hear from them. I was in court and it was a judgment day and my client had just been convicted. He had just been convicted. So upon sentence, usually the court will call on you to make an allocutus. Allocutus means you are asking the court to give a mitigating factor, to look at the mitigating factor that could reduce the prison term. So I stood up and I told the court that he's a first-time offender. He has 6 children. He has a wife that is disabled. And he's the breadwinner of the family. If this court applies the maximum sentence on him, it will mean that his 6 children, his wife, and his ability to cater for them economically would have been trapped under the decision of the state. Therefore, we're going to have more people suffering than one person that's alleged to have committed an offense. And so what would the court do in that instance? A judge will look at it and perhaps if it's going to be 7 years, he might decide to give 3 years. He might decide to give the maximum punishment, or to do anything he wants to do. In the case under reference, we have gotten to that point where we have to decide whether the punishment or the treatment being meted to him is that which could have been meted to any of Nigerian citizens outside the detention walls. If the way he's being treated is not equal to in any other person outside who have not committed an offense, who is not alleged to have committed an offense, in terms of freedom of thought, his movement, of course he's under detention, but his when he is supposed to have visitors, the way he's treated? Is it the way they treat his own visitors, that they treat visitors that are for other detainees? Those are questions we need to ask. And until we put that together, the law enforcement agency must be trained enough to understand that what our duty is prosecution. And when I finished my locutus that day, they asked the prosecution witness to make a statement. Some will say, my lord, the offense was committed, same has been proven, this court should give the maximum penalty. Some prosecutors will say that I will leave this to the court. Some will say, I join my faith with that of the defendant counsel who just gave an locutus, and I plead to the court to consider the mitigating factors. Some prosecutors do it. Because at that point, we are talking about the unity of brotherhood despite the offense committed. Especially when the offense is a penal one or a serious one that requires death penalty. Would you, as a prosecutor, even when you know that after you have done all that, the governor will not stand and there's no hangman standing anywhere? So let's look at Nnamdi Kanu's case from the point of not just sympathy but compassion.
Enterprise TV, a tradition of truth.